Hello again, everybody. Steve Wilder from Sorensen Wilder and Associates with you. Another one of our safety and security podcasts, and I'm really super excited about our guest today. Guy who's a longtime friend. I can't say enough about this guy. We've been friends for a number of years. He is a coworker. His name is Jocko Vermillion. Jocko is the vice president of operations of Sitka, which is a sister company to SWA, owned by the same parent company. And Jocko, and I'm going to let him talk a little bit about his background, but Jocko is a nationally recognized subject matter expert on workplace safety and OSHA compliance. He spent a number of years as an OSHA compliance officer. So, Jocko, welcome. It's great to have you, my friend. What's going on in your world? I mean, I know you guys are busy. What's going on? Anything exciting?
Yeah, thanks, Steve. I appreciate the warm welcome. I appreciate the opportunity of being here today. As you know, I represent a lot of companies during OSHA inspections and OSHA accidents and stuff. So we've been considerably busy this last quarter with the jobs under a rush, trying to get finished before the weather gets bad and buttoning things up so we can work inside.
Good. Now, as I introduced you, I talked about your knowledge of OSHA and your ability to guide companies in compliance. Talk a little bit about your background. I'm sure our listeners would find your credentials to be impeccable, as I do. Talk a little bit about your background and how you got into all this and where it took you.
Well, Steve, I was the vice president of a tower company, and was during my time with the tower company, I had a fatality. A guy fell off to one of my workers. And that was my introduction to OSHA. Up until that time, I didn't know anything about it. And after it was all said and done, OSHA liked what I had done in my company and asked me to teach compliance officers about tower safety. So I started working for the OSHA training institution as an outside contractor, training compliance officers around the United States about tower safety.
And forgive me for interrupting, when you talk about towers, since our listeners don't really know you or your background much, you're talking about cell towers, you're talking about broadcast antennas, you're talking about TV towers, all that kind of stuff.
That's correct. Climbing high climbs, I guess you want to say. And working on tall structures. Sometimes we're on rooftops downtown Chicago, on the buildings changing antennas. Sometimes we're on water tanks. Sometimes we're on 1,500-foot TV towers. So there's a variety of heights and a variety of hazards. So as I went to work for the OSHA Training Institute, training compliance officers, I did that for about 5 years, and then OSHA asked me to come on full-time, and I became a full-time compliance officer in doing inspections and priority inspections around the country. So I was involved in a lot of different types of inspections and a lot of different things, which made it kind of interesting.
When we talk about OSHA compliance, it really doesn't matter, would you agree, what industry we're talking about. It could be construction, it could be towers, it could be healthcare, it could be manufacturing. The tenets of OSHA are pretty much all the same. Would that be a fair statement?
Yes. OSHA's primary part of their job is that they cover employer-employee relationship. So anybody with one employee is covered under the OSHA Act. So that's where they have jurisdiction.
And I appreciate you saying that, because I hear so many clients comment that, and I especially hear this in obviously small businesses, that we have less than 10 employees, so we're not covered. And that's not true. That's just a record keeping issue. Is that correct?
That's correct. If you have one employee, you're covered under the OSHA, or you're subject to follow the OSHA Act.
Right.
And the record keeping basically says that if you have 10 or more employees, you must keep, records, injury and illness records.
Right. you and I have talked many times in the past, and we've worked some client jobs together. Uh, Everybody worries about what they're going to do when OSHA shows up, and we'll talk about that in a few minutes. But my experiences in the safety arena have been that if companies focus on maintaining a safe work environment, doing what's right, knowing the standards, following the standards to the best of their ability, to me, it starts with preparedness.
Well, that's correct, Steve. And a lot of people don't understand, I think, how the OSHA Act actually works. It puts the burden on the employer to furnish a safe and helpful workplace. And I know that it's tough sometimes for employers, trying to make ends meet or cash flow problems, or, they got a lot of things going on, and sometimes safety falls to the background. But that doesn't exempt them from anything. The focus needs to be on safety, and under the Act, they're required to furnish a safe and helpful workplace, every employer.
I know OSHA's got a number of different types of inspections they may show up and do. What are some of the different types of inspections that OSHA performs when they walk into an employer's place?
Well, there's basically four. But first you got to remember that OSHA's inspection process has to do with imminent danger starts first. And that's when they see a process that could or will harm or could kill or harm an employee immediately. And that's called imminent danger. And OSHA gives that top priority.
Okay.
And those don't happen real often. Best example I can give you is somebody standing on a roof 12 stories in the air on the edge of a roof. That would be an imminent danger because it could get blown off or fall off immediately. So they would say that was their top priority and look over all the other problems that they have and go take care of that one first.
Mm-hmm.
The next one would be fatalities and accidents. They give them second priority because usually when you have a fatality or an accident, there's probably a breakdown in your safety program someplace, and they want to try to fix that so nobody else can get hurt. So they give that second priority. They don't want another employee injured in the same process. And then third is the employee complaints or calling complaints. There's a lot of, all the officers get calls every day and have what they call a duty officer to field calls and of complaints, workplace hazards, workplace problems, stuff like that. Those are given third priority. And then a lot of officers do programmed high hazard inspections are fourth priority, like stamping plants. Those are high hazard areas, so they do those kind of inspections. The programmed high hazard inspections, those have been identified, and they have to send their 300 logs in or their record keeping logs every year for OSHA to review them. And they base their inspections off of those record keeping. But keep in mind, not all industries have to send their logs or their record keeping injury and illness logs in to OSHA every year, just the high hazard program.
And that's the high hazard ones based on OSHA's identification of what are hazardous businesses or occupations?
That's correct.
Okay. So I'm sitting here at my desk. It's just another day at work. And all of a sudden, the doorbell rings and there's somebody there that says, "Hi, we're from OSHA and we're here to do a compliance inspection." What should my response be?
Well, first of all, you want to be courteous and invite them in to sit down, okay? And then inspect their credentials. Make sure they are who they are. They should display them right away as they enter, and they're going to offer to do an opening conference. I would advise you to take this opening conference because it's going to tell you why they're there and what their intentions are. And then they may want to perform a walk-around inspection, and then they should have a closing conference. But based on their opening conference, I would that really tells you everything, the reason why they're there. And a lot of times things, they may have gotten a complaint that's not valid, and during their opening conference, they may ask for some paperwork and maybe dismiss it and go right to the closing conference. So always pay attention to the opening conference. Make sure you inspect their credentials. Get a business card so you know who you're talking with for later reference. And then try to provide them with as much information as you can. But I would advise most people, if you're in management, to have somebody sit there with you to represent you. Because what management says is what the company says. So we want to make sure that there's other people in the room, because this is an interview process from the minute he walks in to he's interviewing everybody.
So, and we're going to talk more about that in a couple of minutes, because you really hit on something important right there. Are there limitations to what they can look at or what they can ask you to provide them?
Not really. They can ask anything, and that has to do with what they're interested in. They're not going to ask for stuff they don't need. They're going to ask for stuff that they really think they need to either prove or disprove their case. You have to remember that the compliance officer has a responsibility either to prove you did something wrong or prove you didn't. He has to answer to higher ups, and it takes the same amount of information basically to prove you didn't do anything wrong as it does to prove you did something wrong. So you just have to be cognizant of what you're doing during the inspection. And like I said, I always tell people you should seek representation. Somebody knows what they're doing so they can advise you properly.
Absolutely. Now, you mentioned different things that they might include in the inspection process. You mentioned document review. What might they be looking at when you start talking about document review?
Well, under the standard, like we said earlier, 10 or more employees, you have record keeping 300 logs in 300 days. And they can ask for them if you have 10 or more employees, or they may ask you if you have 10 or more and you have logs. The standard allows them to collect them logs, and you have 4 hours to produce them. Now, most people don't hold you to the 4 hours, but they do ask you to produce your record-keeping logs if you have 10 or more people.
How far back do they go?
Well, they can go back, but normally 5 years is what the precedence has been, 5 years for those. Because they're looking for trends that match the complaint or whatever reason they might be entering their business for.
Okay. Interesting.
And
When you're doing a document review, and I'm kind of asking you to be in the mindset of a compliance officer right now. When you're doing a document review, are you looking at their written safety policies and procedures?
Well, that's not on the 300 log. I would really be looking at the 300 log first to see if there's trends or a lot of injuries in one area. And then I would be looking at your safety and health program to see what it exactly says to mitigate these hazards in that part of your business. So they both kind of go hand in hand. And then I would probably be looking at some interviews to see if their policies are in place or how you're managing your safety and health program, because that's really the key. The standard says you must have a safety and health program and it must be effective. So obviously, if you've got a trend of injuries or something that's kind of not right, you may not have an effective policy. So I may be able to advise you on how to fix the policy to prevent future injuries.
You mentioned interviews. Interviews may be employee interviews, it may be management interviews, correct?
Actually, both. I would want to interview employees. I have the right to interview employees in private because they're protected under 11C of the Act of Retaliation for participating in an OSHA inspection. So I want to interview them and get them to tell me exactly the truth of what's going on here and how management's acting towards these types of hazards. You know, if an employee says, hey, they're out here all the time on me to keep my safety stuff on, and they've written people up, and, you know, I've seen them fire people because they weren't wearing their safety glasses, then that tells me they're really managing their program. But if the employee, for some reason, may not, and I would interview more than one employee sure that I get a consensus. And then I would go back to management and say, you know, what are you guys doing for this? And of course, you know, most of the time management thinks they're doing everything they can. And I truly believe that they believe that, but that's not always true. So, and sometimes you find things that just totally slip through the cracks that they misinterpret. You know, not every manager knows every standard or everything about complete safety in their business. They just, and I think every manager shares the theory of not wanting employees hurt. I don't think there's any managers out there that intentionally want to hurt employees. So.
Right. And I don't think there's any employee that really goes to work in the morning thinking, boy, I hope I get hurt today so I don't have to work all day. I don't think anybody wants to get hurt in the workplace.
I don't think so either. And I've never seen that, you know.
When we talk about employee interviews, I'm the employee you're going to interview. Can I say that I want my boss to be there? I don't want to do this alone.
You can say it, but it won't do you any good. You can do it for union representation if you're a union company.
Unions, it's different, correct?
That's correct. Yeah, you were allowed to have union representation there, but that's all if you're a union company. So, and normally the union guy's not there to answer questions. He's there to make sure I don't violate any of your rights,
right,
which I'm not interested in doing because it doesn't do me any good to get the information I need to go on with my inspection. And I don't recommend that employees get representation because they're under no obligation. They're under no, they broke no laws. They can't be held accountable for anything. And OSHA doesn't. They want to protect employees, not hold them accountable.
Not prosecute them, sure. Okay, so I'm the employee. I say I want my boss there. You say it's good to want things, but it's not going to happen. Do I, as an employee, have the right to say that I don't want to be interviewed?
You sure do. I mean, everybody has their right under the Fifth Amendment, but I don't recommend that because I believe that if you give OSHA the information that they're asking for, they'll do their job and they'll do it properly, and it'll help you and the employer. Number one, it'll make you a safer job site. And number two, it'll help your employer, you know, actually, when you have safer workplace, you have more production and there's more money. So it all comes down to bonuses at the end of the year, too. So you can actually, if you work with OSHA, answer their questions to the best of your knowledge, you can actually help your workplace.
Okay, let's change hats for a minute. I'm the supervisor. I'm the manager, and you're going to interview one of my employees. Can I talk to that employee in advance?
Sure you can. You can talk to him, and I advise that you do. I actually advise you that you go over and introduce me as the compliance officer, and then I want to ask you a few questions, and that I should answer, or you should answer them honestly. OSHA doesn't have the right to say, just go over to an employee and start interviewing. They really need permission from you on who to interview and when to interview and how to interview. And you should do the introduction. You should run the show.
Okay. So I'm going to meet with the employee beforehand. I'm going to tell them, be honest, be forthright. If you don't know the answer to something, say, I don't know. Don't BS your way through it.
Yeah, don't elaborate. Just be honest and answer the question, yes or no, and to the best of your knowledge. And if you don't know, you don't know. No, there's no harm in not knowing the answer to something. You may not be your area of expertise.
And I, when I'm working with clients and you know, they're going to be interviewed, I always tell people, if they ask you the time, tell them the time. Don't tell them how to build a watch.
That's correct. That's correct. You know, sometimes employees tend to elaborate on and want to show how much they know, and really they don't know as much as they think they do. And it can be sometimes frustrating for the compliance officer too, because he's really looking for facts, not how to paint a picture.
Interesting the way you said that. So we talked about employee interviews. You mentioned briefly managerial interviews. So they're going to interview me as a manager. Now, did I understand you correctly? The employee cannot have, a non-union employee cannot have representation in there. But when it comes time to interview the manager, if you're going to interview me and I'm a middle level manager, I can have my supervisor in there for that interview.
You can have your supervisor, your attorney, an OSHA consultant, whoever you wish, and whatever you can have all. Just keep in mind that most of them folks should not be doing the talking, just taking notes and paying attention. The interview should be conducted between you and the OSHA compliance officer. They're only there to observe and take notes.
If, for example, I've got my boss there or I've got my attorney there, whatever the case may be, can I consult with them before I answer a question?
Well, yeah, you can, but you probably won't need to, because the questions are stuff that you're going to know, and this isn't like a courtroom thing. It's basically, what do you know as a manager? You know, do you know this process? Do you know what's going on? Do you know the hazards? Do you know how to protect folks from the hazards? You know, those kind of things. It's not really something that, and there's no criminal matter here either. So It ain't like criminal court.
All right. So we've done document review. We've done employee interviews, managerial interviews. We're going to do a physical plant walkthrough. What are you going to be looking for when you do a physical plant walkthrough, regardless of the type of occupancy it is, whether it's a manufacturing facility, a healthcare facility, a construction site, whatever the case may be? What are you looking for on a physical walkthrough?
Well, a couple things I'm looking for is, number one, I'm looking for hazards. Number one, always looking for hazards. What is going on? And I'm looking at the number of hazards I see. And I'm looking for, housekeeping is a big issue, because that's a big hazard especially a manufacturing plant. And I'm looking at how people are working in the plant. Are they comfortable? Are they productive? You know, are they scared? You know, a lot of things. So I'm looking at what is the process and what is going on. You know, and I'm looking, I'm looking for airflow is one thing, you know, that's health, and what chemicals are around. So I'm looking at a variety of things to ensure their safety.
I always think back a number of years ago, I was doing a mock audit for a grain processing facility in the Midwest. And as we're walking through the plant, the requirements are head protection, eye protection, ear protection. And they didn't provide me. I had my own PPE with me, but so we're walking, and I'm walking with the plant manager, and we identify 2 employees standing over, and this was in a part of the plant where they had processed the grain, and now it's almost in powder form, and it's being filled on a mechanical line into 80-pound bags that'll be shipped out to client sites. And there's 2 workers standing there wearing their head protection, not wearing their eye protection, and they've got their ear protection just kind of dangling around their neck. And I asked the plant manager, I said, where's their supervisor that's being allowed to happen? And he kind of looked down and shuffled his feet a little bit, and he said, the guy on the right is the supervisor. And so, you know, you can't beat management, or you can't beat the employees up when management's not enforcing it. So I think you hit something on the head there.
Yeah, and that's true. And we've seen that many times in the office where, you know, supervisors have actually not been truthful with the owners or whoever's coming in to conduct it. And we've actually seen employers fire supervisors right in the OSHA office during an informal conference. You know, it's important, you know, that you hold your employees accountable for your programs. In that case, you know, their program's not effective. And really, the breakdown is not the employee himself, it's management is your breakdown. So that's the kind of things that OSHA is there to identify, to make sure that employees are safe. And as you know, the grain industry is a highly explosive business.
Exactly.
It's very important that you keep track and keep your programs intact.
Yep. As a matter of fact, I think that, and like I said, it's been a number of years ago, I think that's what brought us in there originally, was that they had a fire in one of their rooftop dust collectors.
Sure.
But let me ask you, you mentioned now, you talked about a number of different parts of the interview, and then it leads up to the closing conference. And you know what? I'm going to hold off on that because I do have one more question on the physical plant walkthrough. Hypothetically, you and I are walking through, you're looking at my operation, you identify a hazard, as you said. If I correct the hazard before the inspection process is wrapped up, is that going to still come back to bite me, or are you going to allow me to correct it and then move on, or how's that going to be handled?
Well, you got to remember that during the walkthrough, I'm allowed to cite any hazard I observe. So, yes, it would be citable, but it would be noted that it was corrected during inspection, which gives you a lesser penalty. And it gives you a little bit of saying, look, good job. So I can choose to, and sometimes I can choose not to. It depends on what it is. Let's say, you know, I do a whole walkthrough and the only thing I find is one employee not wearing his hearing protection when it's needed. The manager goes over and says, look, put your hearing protection in. And he said, yeah, he said, I took it out so I could hear this guy to give him better inspection or instructions. Well, that's really not something that I would personally cite. That's part of, you know, keeping them doing business. So if I saw 20 guys or maybe even 3 guys running around without their hearing protection, then maybe that would change my mind.
Yeah, now we've got to have it.
Yeah.
Yeah, I get it.
My job is to evaluate your programs, really see how your program's working, you know. And so that's what I'm really trying to do. Is it effective?
So then moving on, talking about the closing conference, what should I expect at the closing conference, or how should I conduct myself, or how should we conduct ourselves?
Well, there's normally going to be 2 closing conferences, okay? And I tell this because, you know, if you read everything, there's only 1, but there's 2. I'll have a small closing conference when I leave your facility. And I may say, look, I'm going to send you an email request for some more documents. I may want to come back and interview so-and-so. I'm not sure whether I'm going to cite this here or not. I'm not sure whether it's a citable thing or not citable. And then I'll tell you about the list of things that I did see that I may cite. I won't give you any dollar values or anything like that. And I may leave it kind of an open closing conference, basically, and say, look, I might want to come back. And then once I do my write-up and my supervisor approves everything, then I may either come back or call you and have a closing conference where I explain everything, what I found, why I issued citations, what the citations are, and how you need to abate them, or they were fixed during the inspection.
Okay. So it's over. The closing conference is done. You're gone. And now I get to sit and sweat bullets until I get something in the mail from you.
That's right. You're going to get the citations in the mail. They only become citations when the area director signs them, so you're not going to see my signature. I'm basically done at the closing conference. Then my supervisor or his supervisor, the area director, will take over and issue the citations, and then somebody will schedule. Will tell you your rights will be listed in the closing or in the citations, and I'll give you your options in the closing conference of what you should do when you receive the citation.
What are those options?
Those options are, when you receive the citations, you have 15 working days from the date that you receive them to do one of three things. Number one is you can pay the citations listed on the paperwork. I don't never recommend that. Most of the times, some offices will offer a 30% discount if you pay them that way. So you automatically get 30% off. Number two is you can call and schedule an informal conference with the area director. He's the only one that has the right to amend, delete, reduce, or do anything he wants with a penalty. So I recommend that you come in, plead your case to the area director. It's very informal, and he can listen to what you have to say and adjust penalties or do things as he sees fit. And then the third thing is you have the right to go to court or file notice of contest or contest the citations. Or you can do that up front, but I don't suggest that. But every citation has to be able to hold up within court, and the compliance officer OSHA has to prove their case. So it's a good idea to do the informal conference. If you and the area director can reach an amicable settlement, then you should take it. If not, you should weigh your options, file notice of contest, and get a hearing date in front of an OSHA judge and plead your case and go from there. And most of the time, I think most of my cases, we're able to settle on an informal conference and save the client a lot of money and get a settlement agreement that's good for both OSHA and the client. And the reason I say this is that, some citations are pretty, let's say, go back to the guy standing on the roof that could fall again. And we removed him right away. We retrained him. We did all that. We received a citation for that. And we go in and tell the area director that we've done all these things and bring in the paperwork where we trained him, bought new equipment, showed him how to use it, and then he might give us a reduction on a penalty to compensate us for that. And it might not be worth going to court for because, they've obviously we were wrong.
Attorneys don't work cheap. We all know that. And any of us that have to pay bills for legal counsel know that. When I get the citation, do I need to call my attorney? Should I get my attorney on the case right away?
You can if you want. Certainly, you should seek advisement from a OSHA attorney, somebody that knows about OSHA, because OSHA court is not like criminal court. It's much different. And the truth is that you don't need an attorney. You can go in and represent yourself, or even myself as a consultant can represent you in OSHA court. But I do think that it's a wiser decision to find an attorney that knows OSHA laws and standards and regulations and understands, been to OSHA court, that has experience, and let him be a representative of the company and find you a good expert to testify on your behalf and let the attorney do the work.
And you and I individually and collectively together have worked with clients after they received their citations. We always wish they would have called us at the time because we might have been able to prevent some of that. But at the same time, it's water under the bridge at that point. We've worked with them in remediating the citation amount or the abatement period or whatever it is that needs to be addressed. I like what you said a moment ago about making sure it's an attorney who is experienced dealing with OSHA, because in most cases, your corporate counsel, the client's corporate counsel, is not going to be the attorney that you probably want representing you with OSHA because they don't have the experience with it. and this is a very specialized form of law. Would you agree with that?
I agree, and it's different. It's not a criminal law opinion. It's completely different.
Yeah.
And the other thing I wanted to touch on too, Steve, that if you do contact us up front, especially me, I worked around the United States as an OSHA compliance officer in a lot of different offices around the United States, and I have contacts and friends and people, especially being with the OSHA Training Institute, that I just ran across a compliance officer last week that had been through one of my courses up at OTI and remembered me. So I have contacts, and I'm able to, most of the time, make decent informal settlement agreements. But if you're not always able to, and the reason I say that, because sometimes in a fatality, the OSHA citations are used against you in a lawsuit. So it's much smarter maybe to get an OSHA recognized attorney and maybe go to court and try to either reduce or delete some of these citations, or get the citation changed to something that's probably not have to do with the accident. So we've been able to do that in the informal, is actually get the classification of the citation changed, maybe to, let's say a training violation as proposed to a fall violation.
Right.
That's a little extravagant, but that's kind of what I'm saying. And maybe it didn't have anything to do with the accident itself. It may be just something but the penalty may be the same, but the citation itself didn't really have to do directly with the guy falling into his death or something.
Is there such a thing as, in the legal world, they call it contributory negligence? I'm the employee. You've done a good job training me. You've done a good job testing me. I've shown you in practical assessments and competencies and everything else that I understand the safety steps to be taken. I understand how to follow them. I've demonstrated how to follow them. Then I get out on the job site and I just ignore them and do it my way and get hurt. Is there any defense there for me as an employer that says that, look, I did everything necessary to train this guy properly, including having him demonstrate to me the proper and safe way to do the job. And then when he got out on the field unsupervised, he ignored all that and started taking shortcuts and got hurt. Is there any protection for me in a case like that where I've done everything right?
Well, there's only one, and this is where most employers fail. It's called frequent regular inspections of the job site. Employers are required to conduct frequent regular inspections of the job site, not to ensure the job's going smoothly, but to ensure safety is being followed or their programs are being followed on the job. And then they're expected to discipline them employees when they aren't following the program rules. Let's go back, and it always starts with the employer's knowledge of the OSHA Act. Under 5A of the OSHA Act, it says that the employer is responsible to furnish a safe and helpful workplace. Under 5B of the Act, it says that it's the employee's responsibility to follow the employer's programs. Now, the only way out of a citation like that is to prove that you've been out there vetting your job sites to ensure safety was done. When you found somebody that wasn't following your programs, you issued them discipline or terminated them if it's part of it, multiple times. It has to be progressive discipline. So first time, maybe a verbal warning, second time, maybe a half a day off, third time, maybe 3 days off, and fourth time, maybe termination. So you have to follow those programs, and that's the only way out of it, out of a basic citation. But they do expect you to do frequent regular. Sure. I had a client, or I issued a citation to a company one time, and they had they were supposed to do 2 field inspections a month, but they were doing 1,200 jobs a month. Well, I kind of said, I did the math, and it wasn't quite frequent regular. 2 inspections out of 1,200 jobs wasn't enough to make sure your program was actually working.
Okay. One of the terms, I'm sensitive to our time limits here, but one of the terms that I've heard used in a few different cases is affirmative defense. What is that?
Well, affirmative defense is basically just what I talked about. You have your programs in place, you've been managing them, and you're running the programs, and you've got records that you've done what you're supposed to do, basically.
Okay. All right. So, rose by any other name, I guess. So, we're just about out of time, Jocko. I can't thank you enough for taking time to chat with us this morning. What you got any closing thoughts? I mean, this podcast will be listened
Couple,
to by a lot of different industries, by safety people from a lot of different industries. So, anything you want to give them to walk away with as a closing thought?
yeah, a couple things. I think, one of the hardest things is to, in this day and age, we all need our employees, and we hate to discipline them, or we're afraid they leave or they won't show up for work. But you've got to really, as an employer, you've got to decide whether you want somebody hurt, or you want high workman's comp cost, or you want your programs to be solid. And that's a tough decision. But I tell people, don't be afraid to run your program. And there's always a part of the program that says you can set the employee down and retraining on your safety program. So don't be afraid to use that as one of your disciplinary things. But also, the easiest citation to defend on my end is the one you never get. So don't be afraid to run your safety program and manage your safety program. And don't forget that you have a safety program for a reason. And your employees will be much more productive at the end because they know they're working in a safer environment.
Excellent. Jocko, I can't thank you enough for taking time to be with us this morning. Friends, I know after listening to this, there's probably a lot of questions. If you have questions for Jocko, send them over to us. The email address is SWA at SWA, the number 4, and the word safety.com. And we will get the questions over to Jocko, and we'll get them answered and get them back to you. Jocko, thank you so much. I know our viewers, our listeners are going to get a lot out of this today. I'm sure we're going to have questions coming at you, but I do appreciate your taking the time to be with us today. Friends, thanks for joining us for another podcast today. We'll be continuing to develop these and put them out there to help you in your safety and security program. If you've got any questions, don't ever hesitate to give us a call. Again, the office number is area code 815-933-5977. Until next time, this is Steve Wilder saying stay safe and stay in touch.